Hi students, welcome back to Appleby Academy's classes. So in this video, we are going to discuss a very important topic which is under legal aspects of business, that is our unit 9. So today we will be discussing about the topic stipulation. We are actually discussing this topic in the Sale of Goods Act 1930. So we are actually going through a particular question which got asked for the recent exam, that is for December 2021 and June 2022 merge cycle, and the question which is asked for 29th September 2022 shift 2 for commerce students. So let's see the question. In case of a warranty, the buyer can. Okay, so if it is about some breach related to warranty, what all the buyer will get, like whether he can repudiate the contract, like he can cancel the contract, or he can claim for damage, or he is able to return the goods or refuse to pay the price. So you need to identify the best option in case of something which is related to the breach of warranty, which is not like specified that it's a case of breach, but by seeing the option you will be able to understand that yes, it is something related to a breach related to a warranty. So we will be discussing about stipulation and the categories of warranty and conditions related to Sale of Goods Act. So as I already mentioned, we are discussing this particular topic under the head of Sale of Goods Act 1930. So Sale of Goods Act 1930 means it is this particular act is dealing with the sales of goods. Okay, so which is already mentioned in this particular act. What do you mean by goods as per this particular act, which we already discussed in our previous video. Okay, you can check the previous video which is related to types of goods. And when you're just coming to this particular topic, that is Sale of Goods Act, it is mainly discussing about sale. Okay, it is not at all something related to pledge or mortgage. It is only about sale. It can be the agreement to sell and also case of contract of sale. The Sale of Goods Act deals with Sale of Goods Act 1930. Contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. That means the particular person, that is the seller, is selling his goods to a particular person, that is buyer, for a particular price, for a fixed price. Okay, so this is a situation, or for this we will call as sale, okay, that we will discuss under Sales of Goods Act. And you can see that this particular act is applicable all over India, and as I already mentioned, it deals only with sale, not something related to mortgage or pledge. And here we are considering only about movable goods. Immovable goods are not at all included under Sale of Goods Act, like land, building, such things is not at all included in case of a Sale of Goods Act. Here we will only consider movable goods. Okay, so now we are moving on to our main topic, that is about stipulation. So stipulation, we are just classifying the stipulation into two parts, condition and warranty. As we already see that our question was about this warranty. So what do you mean by the term stipulation? See, stipulation is a very important part which is related to a contract. So let's see, it's a representation which forms a part of contract of sale, and it's affect the contract. So in one way or another way, it is actually affecting the contract. So such important part of a contract is categorized as stipulation. As we already mentioned, we are just categorizing the stipulation into warranty and also condition. So what about this condition and warranty? See, condition is a very essential element of a contract. Okay, it's a very essential element of a contract of sale. So let's see, a stipulation which is most important for the formation of a contract of sale, which is known as condition. But when you're just comparing condition with warranty, which is not so much important like that of a condition, but it is considered as a collateral. That means something which is coming with this condition, but when you're just comparing its importance, this warranty is having only least importance when you're just making a comparison with the in case of a condition. Okay, anyway, these both conditions and stipulation, conditions and warranty, will call them together as stipulation. Condition is a very important part or a major part of contract of sale. So you will understand what is condition and warranty specifically when we just go through a very important example related to this area. Okay, so now just see that condition is a very important part of a contract, which is actually very essential for a contract of sale. But when it comes to warranty, which is not that much important with that of condition, but even though which is also a part which is collateral to the contract of sale. So when we are just moving on to the definitions of condition, let's see, we are actually discussing this condition under section 12 subsection 2. Condition is an essential requirement of the contract on which the whole contract depends and the requirement of the contract is breached, then the sufferer has the absolute right to reject the contract itself. So see, condition is a very important part of a contract, and if the condition which is specified in the contract got breached in some way or another way, what will be the result? In such a case, the sufferer, the person who suffered such a loss can or he have the right to reject the contract. Okay, he can just cancel the contract, he can just repudiate the contract, and in addition he may also maintain an action for damages for the loss suffered. So first of all, he can just cancel the contract, and if any loss suffered by this particular person, he can also claim for damage. That means he can also claim for monetary compensation through suit. Clear? So condition is a very important part of a contract, and if that got breached in any way, the sufferer can actually go for cancelling this particular contract, and he can also claim for damage related to the loss suffered by him. So let's see an example which gives you more clarity. Ram consults Shyam, a motor car dealer, for a car suitable for touring purposes to promote the sale of his product. Shyam suggests Maruti car and accordingly buys it from Shyam. The car turns out to be unfit for the touring purpose. Here the term that the car should be suitable for the touring purpose is a condition of the contract. See, when you're just considering this particular example, so Ram, he just consulted Shyam, and you can see that Shyam is a motor car dealer. So when you're just consulting a motor car dealer, we will assume that, okay, he will know everything about this, all these things which is connected to this. So this Ram he actually required a car which is suitable for touring purpose. So when Ram said this, his purpose, that means I just want a car for a touring purpose, to this person Shyam, he suggested that, okay, you can just buy a Maruti car. But when this Ram started to using this for his purpose, he found that it is not at all suitable for this particular purpose. That means it is not at all suitable for the touring purpose. So here you can see that his main condition, or he specified that he need a car which is for touring purpose, as he already specified with Shyam that this is my purpose with the car. Okay, so by knowing the situation, Shyam just give him a car which is not at all suitable for the purpose of touring. Not at all suitable for touring purpose. So here you can see that the main condition or the main thing which is suggested by Ram was actually breached, because his specification is not at all, this particular car is not at all meeting his specification. So this is considered as a breach of contract, and in this situation, like breach of condition, okay, breach of condition, and you can see that it is so vital that it's not fulfillment of the defects, the purpose for which Ram purchases the car. So Ram actually purchased it for touring purpose, and this car is not at all suitable for such a purpose. So Ram is therefore entitled to reject the car and have the refund price. So in this situation, he can actually reject this car, like he can return this car to Shyam, and he can also claim for a refund. And if there is a case he found any loss related to that, he can also claim for damage. Okay, because this is a main part of contract, that was his purpose, that got failed. In that situation, he can, so if a particular condition got breached, the sufferer can actually go for he can return the goods, he can claim refund, and he can also claim damages if it just created a suffering for a loss for the particular person. Okay. now we will be moving on to the term warranty. We are actually discussing this term under section 12 subsection 3. So what is warranty? Warranty is an addition, or it is a collateral which is related to stipulation and written guarantee that is collateral to the main purpose. So it is something which is coming with the main purpose. Okay. So the effect of the breach of the warranty is that the agreed party cannot repudiate the whole contract. See, he cannot cancel the contract, but what he can do, he can claim for damages. So, but in case of condition, if condition got breached, he can cancel the contract, but it is not actually possible in case of breach of warranty. Here he can just go through, or here the claim that he can do is he can claim the damages only. Okay. So unlike the breach, unlike in case of breach of condition, in the breach of warranty, the buyer cannot treat the goods as repudiated. Like he cannot cancel the contract, he cannot return the goods back to the person. The benefit or the claim that this person is getting, the sufferer is getting, that he can claim damage. That means he can claim for monetary compensation from the seller. So it says that the agreed party has the right to sue for damage only and not to avoid the contract itself. So it is about claiming a damage only. So let's see again an example. Ram buy a new Maruti car from the showroom, and the car is guaranteed against manufacturing defect under normal uses for a period of 1 year from the date of original purchase. And the event of the manufacturing defect, there is a warranty for replacement of defective part if it cannot be a property repaired. If after 6 months Ram find the horn of the car is not working, he cannot terminate the contract. So let's see, in this example, Ram, he bought a Maruti car, and which they already specified that in case of any defect, so if you found any defect for the car within the period of 6 months, okay, it's a warranty for replacement of defective part. They will get replaced if any of the part finds to be which is not able to, they are not able to make a repair, so they will actually replace it within 6 months, which they already mentioned when they just got the contract. Okay, so in this situation, see, he is using the car, and after a certain period he found that the horn is not working. So in this situation, Ram is not able to return this car to the car dealer because it is not a main part, but it is a part, or this is something which is essential but which is not that much important, because in the previous example we know that the purpose entirely got declined, but in this case it is about the defect of a particular part. Okay, so let's see, the manufacturer can either get it repaired or replaced it with a new horn. So here the solution is that the manufacturer can either repair it for him or he can replace it. So the Ram gets the right to claim damage. So here, what is the right that this person is getting? He have the right to claim damage for this. If any suffered by him but not the right to repudiation, whether a stipulation is a condition or warranty depends in each case on the construction of contract. So when you are just going through this particular example, you can see that the horn is not working. This is actually it's a situation of a breach of warranty, not condition. So but when you are just considering different examples, it can be something which be varied related to condition or warranty, because it is according to how that particular contract got formed. If the main purpose got repudiated, like the main purpose got declined in some way or other way, we will consider them as condition. And if it is a part which is not much that important to that condition, we will consider them as stipulation. We will consider them as warranty. So if this warranty got breached, we will have only one solution. That means you can just claim for damage only. Okay, only about claiming damage. You are not able to cancel the contract. But if it is something about condition, what you can do, you can actually cancel the contract. You can ask for replacement. You can actually ask for refunding your product, and you can also, if you got suffered any losses, you can also claim for damage. Okay. And now coming back to our question, in case of a warranty, the buyer can, that means in case of this warranty got breached, you can just go for, can you repudiate the contract? No, you can only repudiate the contract if it is something related to breaching, related to condition. Claim damage only, correct, you can actually claim damage if something which is related to warranty. Return the goods, which is not possible. Refuse to pay the price, which is also not possible in case of warranty. So the correct answer for this question is option B, claim damages only. See, this was a very direct question from the part of Sale of Goods Act. Okay, so in this video we just go through the recent recent question that was held for September 29th for this commerce students on shift 2. So, and we just using this particular question, we discussed a very important area which is related to Sale of Goods Act. So, I hope this video will help you for your preparation. Thank you and happy learning.